The Honorable Mr. Jagdeep Singh, Speaker of the House of Representatives, Senator the Honorable John Jeremy, Senior Counsel and Attorney General, Minister of Justice, Mr. Devish Miraj, other members of the Cabinet, distinguished judges of the Appeal and High Court of Trinidad and Tobago, and other judicial officers, Mrs. Penelope Beckles Robinson, Leader of the Opposition, heads of courts of record, representatives of the legal fraternity of Trinidad and Tobago, representatives of the court administration of the judiciary of Trinidad and Tobago, ladies and gentlemen. We gather today in unusual circumstances. This is the first time that I can recall, apart from the period of enforced restrictions during the COVID-19 pandemic, that we do not have the usual church service and parade to which we all look forward and to which we expect to return next year. Celebrations and commemorations are important. They give us an opportunity to reflect on the importance of our roles and institutions to the maintenance of societal order. They convey a sense of stability and continuity and provide an opportunity to strengthen bonds of unity. But there is another core purpose served by the Chief Justice's speech at the beginning of every law term: accountability. The Chief Justice is responsible for the realization of the judiciary's vision. He or she, with input and assistance of course, is responsible for crafting the strategic direction for the judiciary and ensuring that it is brought to fruition. He or she must therefore account for the judiciary's performance under their stewardship. In that regard, today I want to focus on three primary areas. The first is court performance during the last term, other achievements, and future plans. I will spend some time on structural and administrative reforms and the physical and ICT infrastructure as well. A couple of years ago, we realigned our statistical reporting period to the calendar year. It means that in the September address, as with inflation reports, we get an idea of how we are trending on a year-to-date basis. In that regard, I am happy to report that despite the constraints that we continue to experience and that I have referred to repeatedly in the past, performance is trending in a positive direction. As we seek to consolidate gains, we will be approaching the government with ways in which we can strengthen productive collaboration between the executive and the judicial branches without crossing constitutional boundaries. Regarding High Court performance, I turn first to an area of primary concern given the current crime statistics, and that is the criminal division of the High Court. For the whole of 2024, 393 indictments were determined. From January to June of this year, we were already at 256. 95 of those were filed after a JIPA came into operation in December 2023, which means that the longest time from filing to completion is 18 months, with the average being 11 months. That is our vision for the future. We are coming from a time when the average age of pre-JIPA matters at the time of disposition was well over a decade. JIPA is working, and I attribute that to several factors. There is the increased use of guilty plea arrangements and maximum sentence indications, and I commend the Office of the DPP and the Public Defender's Department for their willingness to collaborate in these processes. The addition of more criminal masters to assist with the case management has definitely made a difference. And bearing in mind that the increase in their numbers has only been from this year, or less than half of the time since JIPA was proclaimed, we expect to see further gains. I should caution, however, that a way must be found to assist the DPP, whose department is suffering from a staff shortage that threatens gains that have and can be realized. The real positive development is a shift in the litigation culture. I have repeatedly said that we cannot try our way out of the backlog, and the profession is catching on. 73% of the AJIPA matters and 62% of the pre-AJIPA matters were determined without a trial. Judge-alone trials are now an important and accepted part of the landscape. 16% of the AJIPA matters and 25% of the pre-AJIPA matters were determined using bench trials. What this means is that only 11% and 13% respectively required jury trials. The time has come to consider making bench trials the default option. I have not heard any general complaints about unjust outcomes. What people are demanding is speedier trials. In that regard, let me say a word about virtual hearings. The judiciary operates a hybrid system of virtual and in-person hearings, used in tandem and as appropriate, depending on the nature of the proceeding or hearing. It has proven to be effective in enhancing speedier and more convenient access to justice. Is it perfect? No. But I am heartened that both our internal survey and the one conducted by the Law Association show a strong preference for the retention of virtual hearings as part of a hybrid system. We welcome feedback from all stakeholders regarding their experiences and their suggestions as to how we can make things better and how our service might be improved. But we are not turning back the clock. With specific reference to initial hearings, my conversations with police prosecutors, they have expressed appreciation for the convenience that virtual appearances provide because they can cover several courts from one location, and issues like a shortage of vehicles to transport prisoners to court can be ameliorated. Of course, I am not privy to spatial arrangements at police stations, and I understand that there's some difficulty in accommodation. We have been operating under a mutual understanding and agreement so far, but if that has to be adjusted, then so be it. We will work collaboratively with the Ministry of Justice and with the Trinidad and Tobago Police Service. However, we don't want courts to be turned into police stations any more than police stations to be turned into courts. We will find a way to work together and find effective solutions. With regard to the Children Court, performance is holding steady. For the whole of 2024, 688 matters were determined. For January to June this year, the figure was 347. So we are tracking pretty much at the same speed. However, I note with concern that the Civilian Conservation Corps apparently has been shut down. This does present a challenge for our commitment to therapeutic and restorative justice, because it was a major alternative to incarceration for young persons who need to be redirected from a trajectory that would lead to habitual reoffending. We hope to have urgent discussions and conversations with the government on this issue. With regard to the High Court Civil, for January to June this year, filings were up 2% to 2,283, while dispositions were up 4% to 2,025, for a clearance rate of 89%. Of those, 48% were less than a year old at the time of disposition, and 70% were less than 3 years old. Well, this is down slightly compared to last year, which is 49% and 76%. We are in the process of recruiting more judges to replace those who we have lost through promotion or attrition due to retirement. There's good news in the Estates Administration Office, formerly called the Probate Department, or Probate Registry. They have achieved a significant milestone in our ongoing efforts to reduce the backlog of estate matters and to improve service delivery. Now, I do appreciate that some individual experiences are not positive, and we have to accept responsibility for any failings and try to do better. But looking at the system as a whole, performance continues to improve. As a result of the backlog reduction project undertaken in the last quarter of 2024, the Estates Administration Office dispatched 5,370 grants, more than double the 2,612 issued in 2023. That's more than a 105% increase in clearance rates. And during the same period this year, the Estates Administration Office also completed over 13,000 searches and processed 11,000 filings. The grants continue this year, or should I say the gains continue this year. 3,151 grants were signed for the first 7 months of 2025. These results highlight the EAO's sustained productivity, faster processing times, and enhanced capacity to assist court customers navigating the probate process. Central to the transformation of the probate registry is the e-services platform, which allows applicants to track filings and receive real-time updates, improving communication and reducing uncertainty through the process. These ongoing improvements reflect a clear shift towards a more responsive, transparent, and service-oriented approach. With continued system upgrades, the Estates Administration Office remains committed to delivering estate services that are efficient, accessible, and aligned with the needs of the public. There has been an interesting development in the family court. Year-to-date filings are down 10% from last year. We should investigate that. While that is a good sign, and determinations are actually up 2% to a total of 4,665, which amounts to a clearance rate of approximately 100%. Unfortunately, the number of domestic violence and maintenance matters in the system remains unacceptably high. In the District Criminal and Traffic Court, filings in January to June this year are down 13% compared to the same period last year. Determinations are down 6% to 5,131. So even though clearance rates have technically crept up, that should not obscure the fact that there is a critical shortage of magistrates, which the Judicial and Legal Service Commission is currently addressing. We are in the middle of a recruitment process and have shortlisted candidates for interview. I turn now to developments with regard to our physical infrastructure. The judiciary of Trinidad and Tobago continues to advance its court infrastructure agenda, balancing long-standing building upgrades with 7 prioritized projects that reflect urgent service demands. While progress has been affected by pandemic disruptions, procurement delays, and vendor transitions, our commitment to delivering safe, functional, and future-ready facilities remains firm. We do not want to be in the construction business, but our institutional memory is shaped by past experiences which have left lasting consequences, including court buildings in Port of Spain, Chaguanas, Princestown, Tunapuna, and Point Fortin, that stand as sobering reminders of what happens when facilities are constructed without meaningful consultation and collaboration. These facilities remain underutilized and in some respects unfit for purpose. A classic example is the new wing of the Port of Spain District Court completed in 1999. When the building was handed over and occupied, numerous deficiencies in design, construction, and equipping of the court were revealed. These included inadequacy of space, an absence of suitable record storage, poorly designed point of entry, and circulation for judicial officers, prisoners, and the public, with the possibility even of magistrates encountering prisoners in the corridor. A design that ignored geometry and the existing watercourse resulted in the inability to access the newly constructed cell block with the prisoner transport. To this day, if that building is to be used, prisoners must exit vehicles on St. Vincent Street, blocking traffic for lengthy periods of time each day. The reasons for these results can be traced back to the ownership and management of judiciary buildings. Judicial buildings are unique and specialized, a fact that is often underestimated by those who have not studied court building design, which is a specialized area of court administration. Court spatial planning, adjacencies, circulation patterns, security, and technology are specialist areas which require the judiciary's lead. We have to be clear about who is the ultimate client as opposed to the project manager. Construction and refurbishment must be done in accordance with approved judiciary design briefs which have existed for some time. I am hopeful that we have begun to turn the corner. The Ministry of Justice has now been given the responsibility of construction and refurbishment of judiciary buildings. And the judiciary welcomes the opportunity to engage in meaningful dialogue on the development of judicial infrastructure. I am encouraged by a recent conversation with the Honorable Minister of Justice in which we agreed on the need for the judiciary's active input to be received and honored. The judiciary looks forward to being part of a process that is a partnership, consultative, transparent, and respectful of the separation of powers. That said, everything that is done now is shaped by current fiscal constraints that dictate a reprioritization of ongoing and future projects. Across the judiciary's portfolio, several buildings are undergoing upgrades, outfitting, or conceptual planning to address, among other things, the impact of aging, expanding access to services, and facilitating technology upgrades. Important active projects include the Port of Spain District Court, where restoration of both wings of this building with civil MEP works already underway and additional upgrades scoped. The San Fernando Supreme Court, where civil and ICT upgrades are in progress, and a new wing to support expanded criminal jurisdiction is also being contemplated. Scope revision and tendering is also underway. As is often the case with old buildings, while initial scopes are prepared, issues outside those captured in the original scope are invariably identified or uncovered once works are commenced. We have also been plagued with contractor delays that have led to firing of contractors. Given the current procurement framework, which requires a lead time of approximately 4 to 6 months and a further 8 months to completion, we do not unfortunately anticipate delivery of these projects until September of 2026. All of this, of course, being dependent on the availability of funds. Another urgent priority is the Family Court North. Family Court North requires a new home. The condition of the existing building is abysmal due to considerable damage caused by a leaking envelope, which, despite years of constant requests to and promises by the landlord, has never been adequately addressed. We need to ensure that there is some level of physical presence for in-person proceedings and/or services, including mediation, intake programs, and hearings. And while repairs to the NIB-owned facility are ongoing, a new home for the Family Court, Port of Spain, is being pursued actively. At this point, the need to occupy a fit-for-purpose space outweighs the ability to wait for the completion of this project. If we are to ensure the delivery of key programs at the Family Court, then we absolutely need a new facility to be identified in very short order, and work needs to be done to make its occupation and full resumption of operations possible. Family Court South, that is the Clooney building in San Fernando, that project is nearing completion, with ICT, security, and the public waiting area being the last of the remaining scope items. In fact, with the appropriate support, including the approvals for staffing, this facility can be operationalized by the end of the first quarter of 2026, bearing in mind, of course, procurement and staffing. Urgent short-term future needs will also include a Family Court for Tobago, well, we have a family court for Tobago, but the new location has to be identified to accommodate the growth in filings and the inclusion of domestic violence matters, which make the current facility inadequate for the volume of matters that need to be addressed. And finally, virtual access customer centers for the maximum security prison. The cost and risk management benefits derive from significantly reducing the transport of prisoners to court demand an urgent increase in facilities to support secure virtual hearings for remanded individuals. So that's a snapshot of some of the physical infrastructure work that is going on and the requirements that will be of immediate interest. I want to deal at some length with the topic of the administration of the judiciary. Not least because there's been a lack of understanding and information in the public sphere. And several people have approached me, some with consternation, about the idea of a Lord Chancellor for the judiciary. I suspect that is because the title carries a great deal of historical baggage. My first response is, do not panic. The Prime Minister has offered to support the judiciary's administration, which is not in itself a bad thing. She has also promised public consultation, to which we look forward. Until there's a concrete proposal to discuss, as in who appoints, who report, the reporting lines, job descriptions, etc., we should not speculate. What I can usefully do at this stage to inform public discussion is to explain a little bit about court administration, its purpose, and why that function has evolved within the judiciary in most developed jurisdictions. The role of the modern judicial officer is not merely an impartial arbiter of a dispute presented to him or her. He or she is also the leader of a team whose responsibility it is, with the support of court administrative staff, to manage a case from filing to disposition with the judicious employment of available resources and in a timely manner to achieve a fair and just result according to law. Now that's a mouthful, but we'll break it down. That's what we call case management. The coordination of all the technology and support processes and services that move all matters through the courts at a systemic level is called case flow management, which is the responsibility of court administration as opposed to the individual judge. Now, a moment's reflection will reveal that this has major implications for the administration of the judiciary, that is, court administration, as opposed to the administration of justice, which is a broader concept with which is sometimes confused. The administration of justice relies on several stakeholders and must involve harmonious collaboration between the executive and the judicial branches of state. But judicial business cannot be separated from the administration of the judiciary. Listing or assignment of judges, record keeping, security, selection, management and sequestration of juries, information technology, training, human resource management, among other things, all impact directly on a judicial officer's ability to deliver justice effectively and impartially. This is a matter both of fact and perception, especially having regard to the fact that the state is a party in virtually all criminal litigation and much of the civil litigation before the courts. So if one is searching for a physical embodiment of the notion of separation of powers, then it may be found in an independent court administration that is answerable to the Chief Justice. Imagine if you were one of the parties to a lawsuit, you probably would not feel comfortable knowing that the party on the opposite side could have access to judges' chambers, to control the filing of documents, the keeping of all the records in the matter, the selection of the judge who would handle the matter, the scheduling of courtrooms and other resources, the composition of the judge's support team, including the research assistant, and all the information technology and associated with the matter and the court, including the leave and travel arrangements and everything. So you might, with some justification, entertain apprehension that the scales can be tilted against you. That's what court administration is about. But I do not imagine that what is being proposed is that intrusive. I do believe that there is a shared desire to see the administration of justice operate more effectively and efficiently, and we should welcome the right type of help. Permit me to share some of my personal views, and I stress that this is how I see it, and the judiciary has no formal position on this, because we have not caucused or canvassed the whole of the bench. In the modern context, the job of Chief Justice is not simply to write judgments. In talking to my international colleagues or compatriots, most of us spend more than 50% of our time on administrative matters. I chose during the pandemic and since to focus almost exclusively on driving the accelerated pace of transformation. I do not presume that most Chief Justices would function that way, at least permanently. The administrative role of Chief Justices can be separated into two parts. First is overseeing the general administration of the judiciary, its registries, processes, and resources, for which court administrators are uniquely qualified and judges are not. All the most senior managers in our court administration have training and/or qualifications in court administration, which is a distinct profession. Under our current system, the court executive administrator, who is responsible for the day-to-day running of court administration, is also a lawyer and, by virtue of the Judicial and Legal Services Act, is a judicial officer appointed by the JLSC. So in a sense, we already have a kind of chancellor. The second role of the Chief Justice is about matters concerning judges and judicial officers, leave, travel, assignments, who receives what training, performance management, HR interventions, etc. Now, judges don't like to take instruction except from a Chief Justice or a judge of more senior status designated from that for that role. In the old days, when the judiciary was a lot smaller, there was something known as a senior puisne judge. Not a formal constitutional office, but someone assigned who assisted the CJ to manage the High Court bench. Some of that work has now been devolved to several committees, and there is a good argument for an administrative judge under the direction of the Chief Justice to deal with those matters, as well as many of the committees in the core court administrative area, which I currently oversee. That doesn't necessarily require constitutional reform. In fact, we are in the process of developing a proposal for the restructuring of the Office of Chief Justice precisely for that purpose. The title and role of Chancellor has evolved differently in different jurisdictions. So, for example, in Guyana, the Chancellor is head of the judiciary, but reports to no one. The Chief Justice presides over the High Court and reports to her. But in Guyana and Jamaica, unlike Trinidad and Tobago, the High Court and the Court of Appeal are presided over by separate persons. Our constitutional arrangement is different. The Chief Justice is both the most senior High Court judge and the President of the Court of Appeal. I say this because we have to work out what this will mean. Okay, and I don't want anybody to get hung up on the word chancellor. Turning to England, the jurisdiction with which most of us are familiar, the most striking difference from our current constitutional arrangement, which is still the subject of vigorous debate there, is that the Lord Chancellor, as a member of the executive, has a role in the appointment of judges. Criticisms have been leveled at the fact that the office holder need not be a lawyer, is not subject to a judicial oath, and may have competing imperatives between their political aspirations and the duty to uphold the independence of the judiciary. So all of these things are things that have to be considered. One of the good things about a healthy democracy is the mechanisms for arriving at a broad consensus or acceptable outcome, even where unanimity of opinion cannot be achieved. Views will differ. What is important is an informed debate where all views are given a respectful hearing. And I expect that to happen. I'm sure that the judiciary in due course will present its collective view. Turning to other administrative issues, good administration is not just about who leads at the top. It cannot be accomplished without the appropriate human resource base. Now, the judiciary's transformation, including the creation of specialized divisions, has to be supported by a revised human resource infrastructure. Our focus remains on providing competent, resilient, and motivated staff. We depend on external stakeholders for staffing and compensation decisions. We have outstanding cabinet notes seeking support teams for the new masters of the High Court appointed in late 2024. While some are operating with borrowed staff, others cannot be fully utilized due to lack of support. This is unsustainable given the workload and public complaints. Another cabinet note that was delayed after years of negotiation affects staffing across the judiciary, including the absence of staffing for Princestown Family Court, which was operationalized in 2021, with staff who were reassigned from other locations. You will recall that I warned last year that this court now risks closure. So, Mr. Attorney, now that you have had a little settling in period, we'll be coming at you. The turnover continues to be a problem due to uncompetitive compensation set by the CPO, which fails to reflect the demanding nature of judicial work. You may recall that in 2023, I raised concerns about inequitable pay for contracted marshal's assistants, whose duties mirror those of permanent staff. The issue remains unresolved in 2025 and has predictably led to legal action. Now, whatever the outcome of that is embarrassing and was avoidable. Both bailiffs, who are public servants, and marshal's assistants, one who are contract employees, perform identical duties using the same tools, facing the same risks. However, the CPO has assigned unequal compensation based solely on employment status. Despite identical duties, they must cover rising fuel and maintenance costs for themselves. With the ABJIPA proclamation and more judges, demand for jurors has increased, adding to their workload. And this disparity has led to an industrial relations dispute, which risks further strain on the justice system. I don't know how many more times that we need to beat this drum, but it needs to be addressed. In the area of ICT staffing, judiciary staff in standardized posts work extended hours due to our operational needs. A request for a duty allowance remains unresolved due to bureaucratic delays. While we are committed to fair industrial relations practices and attracting qualified staff, attrition is rising due to poor compensation, burnout, mental health strain, and lack of work-life balance despite growing public demand for our services. The core issue here remains the lack of operational autonomy. The judiciary advocates for a specialized establishment with permanent pensionable roles, and we really need to have discussions with the executive. While we note the Prime Minister's recent comments on contract employment, and we hope for a meaningful dialogue on how this can be worked out and how structural reform can be constructively engaged. With regard to other achievements, we have introduced a centralized court office in the Criminal High Court, which allows for the rationalization of service delivery across the Criminal High Court. This not only promotes efficiency and the effective use of resources through the streamlining of operations, but it has improved the coordination of services and enhanced the quality of work. By creating specialized tracks to manage pre-AJIPA, sexual offenses, and AJIPA matters to ensure efficient case flow across all case types and age of cases, we have been improving the management of backlog matters and current filings through a JIPA by treating them simultaneously, ensuring that old matters do not become older and new matters do not become old, and also dealing with serious matters such as murder and sexual offenses. Our performance reports indicate that several of these matters have been filed and determined within 1 year, as I mentioned earlier, and the introduction of a differentiated case flow approach has greatly contributed to this improvement. With regard to the district criminal and traffic courts, we were able to review and analyze almost 500 inactive criminal summary cases, matters 15 years and older, as part of a review audit to identify and address bottlenecks, resulting in the disposal of long pending cases and reducing the overall case backlog. We've managed to reduce the backlog in the transmission of committal bundles by 93%, facilitating the transfer of over 900 court records for accused persons committed to stand trial at the High Court. We have been able to reduce the backlog in time allowed warrants by implementing an electronic time allowed register with a monitoring dashboard, which ensures timely enforcement of court orders and facilitates the preparation and issuance of over 3,000 warrants across the district criminal and traffic courts in the past year, thereby improving disposition rates. 3 fully outfitted jury courtrooms have been added to the Omera Judicial Center, increasing courtroom availability and improving access to justice. In the Family and Children Division, the Family Court made important strides in enhancing both its physical infrastructure and its judicial capacity. The preparation of a space in Arima and the construction and outfitting of a new purpose-built facility in San Fernando progressed steadily, while in Tobago, a jurisdictional change took place with the transfer of domestic violence cases from the district court to the family court. This shift now ensures that all such matters are heard holistically within a specialized court system, which allows for a more consistent and trauma-informed approach to handling these cases. Judicial capacity was further strengthened through the appointment of 9 new judicial officers during the period. And though no support teams have been approved to provide support, the work has continued. We have also continued work on the development of draft domestic violence rules aimed at standardizing procedures and enhancing the overall quality and efficiency with which these sensitive matters are handled. There were also significant operational improvements within the Children Court. The successful migration of all case types to an upgraded case management system has allowed for greater efficiency and improved case tracking. A joint referral pathway was developed between the Children Court Drug Treatment Court process and the Adult Drug Treatment Court, allowing children before the family and district courts and adults before the family and criminal courts and affected adults within their household to access coordinated therapeutic services. The court also trained and certified a new cohort of peer resolution youth volunteers, expanding its reach in the delivery of restorative interventions. The Social Services Unit of the Family and Children Division remains a cornerstone of support for children and families across Trinidad and Tobago and provides crucial psychosocial services through in-person, online, and hybrid platforms. These services include clinical interviews, psychological assessments, counseling, therapy, supervised access, specialized psychoeducational groups alongside court and next auxiliary programs designed to promote lasting and positive outcomes. Over the past 2 years, the demand for these services has increased significantly. Between 2024 and 25, counseling services by the family court rose by 77%, with co-parenting counseling experiencing a 163% growth, and individual counseling increasing by 34%. I don't need to tell you that our resources are significantly strained. Supervised access continues to support 92 active cases, reflecting our commitment to assisting families outside of regular hours. This is an area that requires special attention and resourcing to meet the needs of families. The children court recorded similar increases, with in-person therapy up by 57%, psychotherapy up by 46%, resulting in a 15% overall rise in therapeutic and counseling services. To meet this demand, the unit introduced a pooled service delivery model in 2025, which has reduced wait times, and enabled the enrollment of 323 participants across programs such as Parent Support Program, Imani Healing Circle, Girls Circle, and Life Lessons. In the Finance Division, implementation of Phase 1 of the Judiciary e-tender and procurement management solution for contracts over $1 million commenced. Phase 2 will include an e-tender solution for simplified procurement activities involving contracts under $1 million and should be implemented in the second quarter of 2026 fiscal year. This solution will improve recording and reporting capabilities on procurement activities. It will facilitate more effective contract engagement and improve accountability for asset and inventory management. The achievements continue. In the area of ICT, an initiative was undertaken to comprehensively modernize the ICT and audiovisual infrastructure within the criminal division courtrooms. The scope of this project included facilitating hybrid court proceedings through secure video conferencing, integrating digital evidence presentation, upgrading our court audio digital recording systems for a more modern and reliable solution, establishing a technology framework to enable live streaming of court proceedings, thereby promoting greater public access to justice, and deploying an upgraded network architecture to monitor remotely deploying an upgraded network architecture to support remote monitoring, management, and technical support of courtroom devices. Of the total of 69 courtrooms across the judiciary which have been identified for upgrade, hardware installation has been completed in 18 courtrooms at the Hall of Justice. Software configuration and end-user training are scheduled for upcoming phases of implementation. As at the end of June 2025, 17 existing prison virtual access customer or VACs locations were successfully upgraded from proprietary communication systems to a more adaptable technology solution. This enables more effective digital evidence presentation during remote court proceedings. A self-help portal has been launched and is actively being used by the public. The self-help portal is a digital gateway for citizens who need to engage with the courts without always relying on in-person contact. It provides step-by-step digital guidance, including downloadable templates and forms, and practical resources tailored for self-represented litigants and members of the public, as well as status tracking. Users can navigate common legal processes with greater confidence, access information at any time, and reduce errors that often slow case progression. We have established a Judiciary Innovation Lab as a forward-looking environment designed to keep the judiciary ahead of the curve in emerging technologies. The lab will incubate, test, and deploy innovative projects, including those involving artificial intelligence and other tools, with a focus on improving access to justice and enhancing services for the public. It ensures that the judiciary is not only ready for change, but is continuously future ready. These are some of the more significant developments within the past year. A more comprehensive list will be available on the website and our official social media channels. But please allow me to extend my thanks to all of our external stakeholders who have contributed to what we have achieved during this recently concluded law term. I am referring to the many ministries and state agencies, diplomatic missions, international organizations, religious bodies, academia, and civil society entities. Without your input, collaboration, guidance where relevant, Our efforts and your overall partnership, our efforts would not have done the quantity of fruit that they did. We look forward to the further deepening of our relationship for the dispensation of justice and for the good of the people of our beloved country. Let me now address future plans. During this year, we plan to develop and launch a simplified procedure for handling small estates in the Estate Administration Office. A simplified procedure to reduce delays in the petty civil jurisdiction. We will also continue with the deployment of virtual access customer centers. The old mayoral district court reconfiguration was commenced last year to provide services including filing, e-payments, and attendance at hearings. The works are almost completed and the public should have access by the end of 2025. We are exploring options in Tobago for those requiring access outside of the catchment area of Scarborough and Crown Point. And it is hoped that our engagement with the Ministry of Justice towards the providing of appropriate access will assist in accomplishing this objective. With regard to court annex mediation infrastructure, since my last speech, the judiciary has received approval for the staffing structure of the mediation unit, although terms and conditions remain outstanding from the CPA. Nevertheless, we have recruited and onboarded staff to operationalize the unit's functions based on interim terms and conditions. The unit will coordinate ADR resolution procedures at the High Court and Petty Civil Court and will support court-connected mediation referrals, scheduling of certified mediators, integration of mediation into the case management pathways. And to implement this, we will engage our key stakeholders, including the general public, the Law Association, the Legal Aid and Advisory Authority, ministries and departments, the Hugh Wooding Law School, and representatives from the business and finance community. The goal is to introduce a culture where mediation is an integral part of civil justice, not a peripheral option. This approach is already being modeled in family court practice. We are undergoing a jurisdictional shift or realignment with indictable matters transitioning to the High Court since the December 2023 proclamation of a JIPA, and family matters gradually migrating from district courts to the family court, and with the plans for the small claims court with a dedicated focus on management and rules. The magistracy is therefore being further reshaped. The recalibration will also enable summary offences to receive the needed balance between swift adjudication and procedural fairness, while petty civil or small claims matters will be managed in a manner that supports early resolution, reduced costs for litigants, and dignity for customers. Traffic violations, which demand speed, clarity, and procedural consistency, will receive the resources and treatment needed. A little bit about artificial intelligence. As we know, artificial intelligence is not a distant frontier in courts. It is already contributing to court operations and to how legal research is done and how justice is delivered, understood, and experienced. In our preliminary exploration, we are looking at guided interviews that help self-represented litigants navigate complex procedures, to logic-based triage systems that prioritize urgent or high-impact matters. AI will continue to support the rollout of our self-service portal and help us to design inclusive digital pathways for persons with disabilities and those without legal representation. Courts worldwide are using large language models, automated scheduling, and predictive analysis to reduce delays, improve access, and support judicial decision-making. We are actively exploring these technologies, hence the establishment of the Innovation Laboratory, always within the context of ethical safeguards and with public trust at the center. AI, of course, will never replace the human values that define justice. It will not replace empathy, discretion, or dignity. It will support them. It will allow our judges, judicial officers, registrars, and court staff to focus on what matters most: listening, deciding, and serving with care. We do plan to introduce live streaming, first in the Court of Appeal, and following that, the Criminal Division. This is an affirmation of our commitment to open justice, public education, and accountability. Live streaming complements our reforms in virtual hearings, self-service portals, and public engagement. It will allow students, journalists, legal professionals, and everyday citizens to witness the administration of justice and help to increase public trust in the courts by demystifying the legal process. Rollout will begin upon finalization of parameters with select proceedings, those of high public interest or significance, while ensuring that the privacy, security, and judicial discretion remain paramount. Judges will retain full authority to exclude sensitive matters or evidence or to protect vulnerable parties. Our protocols will balance openness with fairness, respect, and dignity. With regard to the issue of public trust and confidence, while improvements in efficiency must be an ongoing pursuit, we are also mindful of our vision statement that speaks to accountability and attracting public trust and confidence. We are in a low trust society where regard for public figures and institutions is at its lowest ebb. It is therefore more important now than ever before to adopt transparent accountability mechanisms with enforceable sanctions that are binding on all judicial officers and free from political influence. Most judges are no trouble at all, but one or two are adept at walking close to the edge. Legitimate complaints can be made about delayed judgments, misrepresentations, such as are in the public domain that attract no consequences, inappropriate engagement with the media, and other transgressions. But short of impeachment, the Chief Justice and the JLSC have no means of sanction other than to write or have a conversation in the hope that mature reflection would bring about behavior change. People don't always do the right thing when a hard conversation is had. Impeaching a judge does not get judgments written. The public and our colleagues deserve more than that. Many jurisdictions have a system of graduated sanctions that can be applied after due process has been observed. It cannot be a detrimental alteration of our terms and conditions to ask us to comply with a mandatory code along the lines of the guidelines already voluntarily adopted and which are designed according to the Bangalore Principles of Judicial Conduct to protect the public. Beyond alacrity in the delivery of judgment, public trust and confidence is also sustained by the effectiveness and quality of the judges and the jurisprudence that we generate. In that regard, I am confident that we have a bench that is strong in intellect and independence. However, as we have expanded and as attrition takes its toll, it is becoming increasingly difficult to recruit judges and judicial officers who can function effectively immediately upon assumption of office. As I mentioned earlier, the job of a modern judge is complex, and nothing that is taught at law school or that is normally encountered in practice at the bar adequately prepares one for the job. We have had to expand the content and duration of our induction programs to bridge the gap. Being a bright or able lawyer does not guarantee that transition to the bench can be effectively negotiated, despite the care that we have taken with a refined recruitment process that has actually produced better candidates. During this coming year, we will be losing 3 Court of Appeal judges to retirement. They will have to be replaced by promotions. The High Court bench will be further denuded by the departure of judges who choose to retire or who have reached the mandatory retirement age. It has become increasingly difficult to find replacements, and we are pulling from a dwindling pool in competition with other important public offices such as the DPP. The unavailability of suitable candidates will threaten to undermine the gains that we have made, particularly in the criminal justice system. The time has come to consider the model of some civil law jurisdictions that have a judicial college with a program of study and practice specifically designed for those who wish to pursue a career on the bench. Successful completion of this program before appointment would give the aspirant a clear insight into the job, would give the JLSC a clear insight into the aspirant, so that both parties can decide whether a permanent appointment would be mutually beneficial. Delivery of the curriculum would have to be planned to accommodate lawyers who cannot afford to leave their existing practice to have a trial. I suspect that there are many potential candidates out there who may not even have thought about a judicial career, or whose exposure may not currently make them preferred candidates, but who with the right exposure and training could become very competent judicial officers. I have spent some time talking about current achievements and future plans, but it is helpful and appropriate to place these achievements into the context of the larger vision that is being pursued. So I must also give account of my tenure over the last 17 and a half years. I promised to improve service delivery by leveraging technology, re-engineering processes, and providing a service that was not only more efficient, but also relevant to customer needs. The judiciary can be justifiably proud of the developments and structural reforms that have enabled us to deliver a better service. This is not an exhaustive list, but I will name a few. Regarding structural changes and operationalizing of new courts, we have established a children court, family court Tobago, drug treatment courts, district criminal and traffic courts, virtual courts, and we have divisionalized the High Court for greater efficiency. In the area of legal framework and procedural reforms, in terms of practice and procedural innovations, we have either instituted or enhanced judges' rules for children, continued the implementation of the civil proceedings rules, the criminal procedure rules, maximum sentence indications, increased use of plea bargaining, and judge-alone trials. In the area of judicial governance and education, our institutional development and capacity building was advanced by the establishment of a transparent and merit-based competitive system for appointment of all judicial officers. We formalized the Judicial Education Institute, which also assists in delivering training for the Law Association and other stakeholders such as the police. Just Connect, a virtual knowledge management platform in collaboration with the National Center for State Courts and other regional judiciaries for self-paced learning and synchronous presentation. In the area of digital transformation and technology, we have seen technology-driven initiatives to improve efficiency and access. A bespoke electronic case management information system, Case Center, which is a document and trial management solution, e-filing and document verification, digital voice transcription, a JIPA, and e-payments for maintenance, fines, and fees. Within the limits imposed by budgetary constraints, there have been significant physical and administrative upgrades to support judicial operations. There's the upgrading and expansion of physical infrastructure, for example, Omera, the Waterfront Judicial Center, and at the Hall of Justice. The reorganization of the Estates Administration or Probate Department. This is not an exhaustive list, and it is no small achievement in the context of a system of public sector governance and management that is seriously dysfunctional. But I am satisfied that we're in a much better place now than we were in 2008. When I became Chief Justice in 2008, the mandatory retirement age was 65. That was what I envisaged, and that is what I prepared for. One must have a life beyond Chief Justice. High public office requires sacrifice of family, self, and the freedom to pursue other avenues of interest. And while it is a privilege to serve, each of us must decide about what we want for ourselves at any given stage in life. Chief Justice is what I do, it's not who I am. And over the past 2 years, as I've approached the age of 65, I have seen my life journey with greater clarity and perspective. From a corporate governance standpoint, no matter how innovative a leader may be, an infusion of fresh ideas from a new leader with different strengths and weaknesses is desirable from time to time. It is also important for me to find new challenges and opportunities as I continue to grow. The office of Chief Justice is not private property or something you own or cling to. It is a sacred battle held in trust for one's successors and the nation. I am but a single runner in a never-ending relay, and the baton must be passed at some time. As any runner will tell you, the race is compromised if you don't pass in the zone, and I am in my zone. I have decided to retire, not resign, retire, at a time of my own choosing, and not to wait until I reach the age of 70. There will always be unfinished business, no matter when I leave, but I have decided to retire during this term, so this will be my last speech. I've chosen to make this announcement now because I must be responsible in managing transition, especially after such a lengthy period in office, where the only leader most people in the judiciary know is me. Transparency and seamless succession are an important part of good corporate governance. It requires careful planning and preparation and a reasonable lead time. The departure of my predecessors, whose attainment of mandatory retirement age was of course predictable and therefore anticipated. Um, it's a different circumstance to now. But in terms of preparation time, it should be no different. A further announcement will be made closer to the time of my departure. But it has been a remarkable journey, made even more fulfilling by the opportunity to work with so many outstanding people who put the lie to the notion that all public servants, whether permanent or on contract, are lazy, inefficient, unimaginative, and lack creativity. I have had and continue to have the support of a phenomenal management team, now led by Ms. Jamie Filbert, who have caught the vision and do not need any prompting to execute. I do not have time to name everyone past and present, and I will thank them individually at the appropriate time. But there's one individual who I must publicly acknowledge, and that is Master Morris Allen, whose contribution to judiciary reform and reengineering spans decades. I have also been buoyed by the support and camaraderie of my fellow judges and judicial officers who have sharpened my reasoning by their incisive comments, who have helped to shoulder the burden of management by serving on committees and leading initiatives, who have given the time and energy to the JEI or other committees, or who have simply offered a word of encouragement when needed. I could not run the judiciary without them. I would like to thank all of the support and ancillary staff. Without you, there is no court. I especially want to thank my little team in the Office of Chief Justice, who have patiently surrounded me with unstinting generosity and love, even when I've been a little ratty, and followed me on their job descriptions to ensure my well-being and effectiveness. Most importantly, I would like to thank my wife and family for their unwavering love and support. The families of public figures suffer much more than we do. They suffer in silence for choices that we make. They give up the time and the attention that they are due and absorb the collateral damage from the slings and arrows that are aimed at us. This can be a cruel society, and I have no idea how I would have managed without them. Finally, I thank God for the privilege of serving. It's an honor. At the right time, Her Excellency will choose a successor. Whoever that may be, I am confident that the judiciary will be in good hands because there is more than a critical mass of people who understand and are committed to our vision and mission and who share the ability and the commitment necessary to execute. The next Chief Justice will have my full support, but no unsolicited advice. Before I conclude, I must note the impending departure during this term of a significant component of our bench due to retirement and thank them for their sterling service and invaluable contribution to our jurisprudence. Justices Barrow and Musai and I were sworn in as permanent judges on the same day. They have become the backbone of the Court of Appeal as the two most senior judges apart from myself and currently chair the two appellate panels. I thank them now because I will not have an opportunity to do so publicly next year. Justice of Appeal Aboud, who joined us more recently, has also distinguished himself. His elevation to the Court of Appeal did not take long, and he has made a significant contribution. The work of trial judges is no less important than that of appellate judges, simply different. And those who work at the trial level handle impossible volumes of work that can sometimes be overwhelming. As we will be saying goodbye to Justices Tam and Ram Kerising, I would like to thank them as well for their work in the family division. Last but no least, by no means least, I have to say thank you to retired Justice of Appeal Malcolm Holip, who happily is present with us today. He departed at the end of the last term. His compassion led him to go the extra mile with initiatives like the Bail Boys Project, and we miss his buoyant personality that made court an easy experience for judges and parties alike. In a real sense, we are witnessing a generational baton passing. It's not just at the level of Chief Justice. All that remains for me now is to thank all who have worked tirelessly in the past few weeks to organize today's sitting, and to thank all of you who have attended in person or listened online for making the effort to spend the last hour with us. I thank you for the courtesy of your attention. May God bless us all, and may God bless our nation. This court now stands adjourned. All right.
This is TTT, Live for Local.
We rolling big with NLCB, Playway, and Fast Cash. Now, there's a jackpot after every draw. Just place your bet with any Mega Mix option or Monster Draw and get your jackpot numbers at no additional cost. Then match your jackpot numbers in any order for a chance to win big. And the bigger your wager, the bigger your win.